Let me introduce our presenter. This is Helen Newberry. She has been an attorney at the Center for Arkansas Legal Services since 2018. She's currently their disaster response attorney. The Center for Arkansas Legal Services is a nonprofit organization that provides free legal services to low-income individuals residing in the state of Arkansas in civil, that is, non-criminal cases. The Center for Arkansas Legal Services is headquartered in Little Rock, and they serve 44 out of the 75 counties in Arkansas. That's most of them. So I am going to turn it on over to Helen now and get this off the screen. So take it away.
All right, thanks. Okay. Sorry, I'm trying to set up, share the presentation.
Go for it.
Okay. Can you see it?
Yep, we got it.
Okay, perfect. Okay, so this is the fourth and final Lawyer in the Library presentation. Today we're going to talk about family law and advanced directives. It's things like wills and powers of attorney. Okay, so as Nathan said, the Center for Arkansas Legal Services provides free civil legal aid to Arkansans in our 44 county district. We have offices in Little Rock, Hot Springs, Pine Bluff, Fort Smith, El Dorado, and we have an office in Russellville. If you would like to apply for assistance, you can go to our statewide website at arlegalservices.org/apply online, or you can call our helpline. Our helpline number is 1-800-950-5817. That helpline is open Monday through Friday from 9 a.m. to 11 a.m. and then 1 p.m. to 3 p.m. As Nathan said, if you have any questions about this PowerPoint or about this presentation, you can contact me at my email address, which will be at the end of the PowerPoint. However, if you have any specific legal questions, if you're asking for advice, or if you're trying to see if legal services will take your case, please either visit the website or call the phone number, because all I can do is refer you to those things. I can't give legal advice just from people who email me. So if you have a legal issue, please, we would love for you to call the helpline at 1-800-950-5817. We also have a new website that is currently under construction. You can visit that at arkansaslegal.org. So our services, like Nathan told you, I'm the disaster response attorney. That means that the people I help are people who are affected by the 2019 Arkansas River flood. I've been helping people with things like damage to public utilities, landlord-tenant disputes, contractor issues, family conflict, public benefits, unemployment, and FEMA appeals. A very big source of traffic we've been seeing is COVID-19 affected individuals. If you are affected by COVID-19 and you're having any legal issues, right now the biggest one is evictions, please call the helpline. Like I said, we will take any kind of civil law, but right now for COVID-19, evictions are our big focus. So today we're going to talk about family law, which will include divorce, child custody, child support, adoption, and guardianships. And then at the end, we're going to talk about end-of-life planning, including powers of attorney, living wills, advanced directives, and wills. So in Arkansas, to get a divorce, you have to have grounds. The most common grounds for divorce are general indignities, and that basically means your spouse has made your life so intolerable continuously that you are no longer able to remain married to your spouse. There's also one called 18-month separation, and that means that you've lived separate from your spouse for 18 months. You haven't been living as man and wife. You haven't cohabitated. We don't have a no-fault divorce ground here in Arkansas. I know that some states have something called irreconcilable differences, We don't have that here. The closest thing to no fault that we have is the 18-month separation. Otherwise, you're going to have to allege some kind of grounds to get a divorce in Arkansas. There are other grounds. These are just the two most common, but they're going to vary depending on your situation. So the divorce process. So what happens? Well, first you file the complaint saying what your grounds are for the divorce and what kind of relief you want from the court. If you want support for you or your children, if you want specific property from the marriage, that's all in the complaint. So the next thing you do is serve your spouse. You can either have it delivered by hand with something called a process server or a sheriff, or you can get it via mail using certified restricted return receipt requested delivery. So that's when it starts to get kind of difficult for people to do divorces on their own, is that service stuff. So after you serve your spouse has 30 days to file an answer. Unless they're in prison, then they get 60. So after the answer, if an answer is filed, then you can ask for a hearing. If an answer is not filed, you have to wait either 30 or 60 days, and then you'll ask for a hearing from the court. When you go to your hearing, always bring at least one witness to testify that you've lived in Arkansas for at least 60 days prior to filing your divorce, and to testify to any grounds or any other facts. For example, if your grounds are if your grounds are that your spouse has been abusing you, you'll need someone to testify that that's something that happened. If you want, say, supervised visitation for your children, you need to bring a witness to say why that should happen and what they've seen that can tend to prove that the visitation needs to be supervised. So one thing a lot of my clients say when we talk about divorce is, my spouse refuses to sign for the divorce. So that's not the way divorce works. As long as you can get good service on them, as long as you can make sure that the court sees that they have gotten that complaint, they don't have to sign anything. Now, of course, it's better if everyone agrees and works out an agreement for the divorce that both spouses will sign, but you don't have to get your spouse to sign something. You can't be held hostage and have to remain married to them forever just because they don't want to agree to anything. So child custody. Child custody is awarded by a court based on the best interest of the child. This is the legal bar that the court uses to determine who should have custody or who should have full custody. The best interest of the child. That's what's really important. Now, if there has been a custody determination and you want to change custody, the court will not hear your petition to change custody unless there's been a material change of circumstances. Now, this can be something like the custodial parent is moving out of state, or the custodial parent has started using drugs, or the custodial parent has started a relationship with someone who is abusive. So of course you have to prove those things, but it has to be a material change of circumstances in order to change custody. You can't just decide you're sick of sharing custody with your ex-spouse. Another important point is, in unmarried couples, the mother of the children is the legal custody until the father files a suit for paternity, custody, or visitation. That means if you are an unmarried mother and you have 2 kids with your ex, you don't have to go to court to get custody. You already have custody. It's up to your father, or your children's father, to file something in court if he wants to get custody or visitation. Once again, it's not up to you. You already have legal custody if you are the mother and you were unmarried at the time of the children's birth. So a little bit about child support. Child support is usually administered by the Office of Child Support Enforcement. Support is determined by specific guidelines created by the Supreme Court of Arkansas. It's called Administrative Order 10. It's pretty complicated. It involves a lot of math and involves finding out what everyone makes. We actually have new guidelines this year in Arkansas. Our prior guidelines, we would just need the income information of the person paying child support. But now we have to have the income of both parents, and it's calculated using both parents' income. Just so you know, your wages can be garnished for child support if you are behind. Your tax return may be seized for child support as well. So some issues with child support that I've seen. One is child support is meant for the support of your child. Even if the custodial parent that you're paying child support to isn't letting you visit your children, you can't withhold child support because of that. If you have an issue with visitation, you have to petition the court. You can't take matters in your own hands and withhold that money. The money is meant for your child, not for your ex-spouse or the mother or father of your children. Visitation and child support are not connected in any way, so you're going to have to continue paying even if the other parent is not letting you visit the child. Another thing is, if you're being garnished for a child that's not yours, you can petition the court to test for paternity. If you are paying child support on a child that you don't think is yours, I would recommend doing this immediately. You won't receive a refund for any past support you've paid if it turns out you're not the father. However, you won't have to pay any future child support. So definitely, this is something you want to, be on. You don't want to wait a couple months and keep paying support if you don't think that you should be paying support if the child isn't yours. Finally, a lot of couples will make informal agreements. Let's say one example is the father will take the children Christmas shopping. He will take the children shopping for back to school clothes and supplies. And let's say he'll pay $200 a week to the mother for the care of the children. But this is an agreement that was made between the mother and father. If you're the father and you're paying these things, you need to keep all of your receipts. You need to keep any kind of money order receipts for what you've paid. You need to keep a record of anything you've paid for through cash checks or your bank statements, because if that relationship crumbles and the other parent wants to take you to court for child support, if you can't show that you've been paying, you could be ordered to pay even more, like you weren't paying all along. So always keep a record of any support that you are paying to the other parent if you have an out-of-court agreement. So we're going to move on to adoption. Adoption is, I'm sure everybody knows, but adoption is when someone other than the biological parent of a child assumes legal responsibility for the child. For this to happen, the parental rights have to be terminated from the biological parents. But the bright side of this is the adoption means that the child has the same legal rights as a biological child. So if you have an adopted child and your biological child, they will inherit under the law as though they're both your biological child. Anyone can be adopted, even an adult, and adoptions can be filed by individuals or through private agencies, or even be arranged through DHS. So let's say that you are trying to adopt. The process and amount of time it takes depends on what type of adoption it is, whether it's private or through DHS or through a private company. But the process usually includes the same kind of things. The first thing is the petition for adoption gets filed. Next, you have to have a consent or waiver of consent from biological parents if the parental rights have not already been terminated. A lot of times in cases with DHS, those parental rights may have already been terminated, so you won't need this consent or waiver of consent. Another thing you have to file is a sworn affidavit about the expenses of the adoption. If the mother was unmarried, you will need a certified statement from the putative father registry. That's kind of the registry that keeps track of possible fathers for children of unmarried mothers. There will have to be a home study done, and you'll have to pay for it. There will have to be a child study report done, and you'll probably have to pay for that too. And then finally, there's hearing and placement. So guardianships. There are two kinds of guardianships. You can get a guardianship over a minor, a guardianship over an adult. For minors, this means for children, if you're trying to get guardianship of another person's child, first of all, parental consent makes it easier, both for you and for the parent should they wish to revoke the guardianship in the future. A guardianship has to go through court. The guardianship probably won't be granted if the parent hasn't been found unfit. So unless the court specifically says that this parent is unfit, the court will not grant the petition, most likely. Because this is a court process and it's expensive and it's complicated, when you have a situation where there are children and you're having to take care of a relative or a friend's children, it's a lot better to have them execute something called a power of attorney for a minor. It's a lot better to do that than to get a guardianship. Guardianships are expensive. Like I said, they take a long time, and it usually really damages the relationship you may have with that friend or family member if you're trying to get a guardianship over their children. Another kind of guardianship is for adults. The adults that would likely have a guardianship put on them either have a disability where they can't take care of themselves, they're a chronic user of drugs or alcohol, or they have some type of condition that makes them unable to manage their own health, safety, or finances. These guardianships are more common, and they're usually less volatile than one for a child. So serving as a guardian, who can be a guardian? You have to be a resident of the state if you're filing it in Arkansas. You have to be 18 or older. You have to be of sound mind, which means that you can make decisions for yourself and for your ward, the person you have a guardianship over. There was also a limitation for people who had felonies, but now the law has changed a little bit. So if you have a felony, you still need to tell that to your attorney, but it might not automatically preclude you from getting a guardianship. And what does the guardian do? The guardian takes care of the ward. The guardian takes care of the ward's property. And the guardian must file a report about the ward once a year in the court. This ensures that the ward isn't being abused or taken advantage of. Just a moment, sorry. Having to mute someone. Okay, so the process of a guardianship for an adult, the petition is filed in the circuit court of the county where the ward lives. So if you live in Pulaski County, but the ward lives in Jefferson County right now, you're gonna have to file it in Jefferson County. The ward must be served with a petition. They have to be served with a special notice of the hearing, and they have to be informed of their rights. This means that they have to get a letter along with the petition telling them what their rights are. To get a guardianship of an adult, a professional evaluation has to have been made within the last 6 months. If that hasn't been done, the judge will order it, and it might be something that you have to pay for or something that may be taken out of the ward's estate, their property. There will be a hearing, and if the guardianship is granted, the judge will enter an order of guardianship, and the clerk will give you letters of guardianship to prove that you have this guardianship over this person. Once again, I'm talking about adult guardianships here. So what does the judge consider for adult guardianships? The judge will consider if the ward is actually incapacitated and how incapacitated. Let's say the ward has MS and is unable to bathe themselves and feed themselves, otherwise care for themselves, but they can manage their own affairs. The judge will try and limit the guardianship as much as possible so that it doesn't take away the freedom of the ward. Another thing the judge considers is whether something else can be done to help the ward besides guardianship, because guardianship restricts the rights of someone so much that the court doesn't like to grant them unless it has to. Another thing is whether the guardianship is in the ward's best interest. So to end a guardianship, this is once again for specifically an adult guardianship. If the ward dies or moves out of state, that'll end the guardianship. If the judge finds that the ward is now competent, let's say that the ward had some kind of drug addiction, and so a guardianship was entered. If the judge finds that the ward has recovered and is successfully staying drug-free, then that guardianship will probably be terminated. Or if the judge finds that guardianship is no longer in the ward's best interest, this would be something like if the guardian was taking advantage of the ward or stealing the ward's money. So some final thoughts on guardianships. I really have a lot of thoughts about this. I think that there's usually a better way to accomplish what you're trying to do than a guardianship. They are necessary sometimes, but some things to consider is that guardianships are expensive. They take a lot of work. They take a lot of time. Guardianships for adults take away the ward's ability to care for themselves. Another thing about children, guardianships for children can be difficult to obtain and greatly damage the relationship between the parents and the person that wants the guardianship. I've seen it firsthand, and it's really unhappy. And no matter what the outcome is, there's a lot of damage done. Other options to consider include powers of attorney, which we're going to talk about in a minute. Conservatorships, which is kind of like a voluntary guardianship, and living wills, which we'll talk about in a minute. So life and end of planning. So the purpose of these documents are to communicate your healthcare wishes, your financial management wishes, and your estate plan wishes. Basically, what do you want to happen with yourself and what do you want to happen with your stuff? The best thing, of course, and I always encourage this, is to talk with your family. It's the first step to ensuring that your wishes are followed. These documents can keep your family members from having to make those hard decisions, but it's good to be able to talk about them as well so that they're ready. When the time comes, your loved ones won't have to make hard decisions for you without your input if you have these documents in place. So who needs these documents? Everybody needs at least one of these documents. We are all, unfortunately, going to pass away one day. So everyone needs a will, at the very least. Everyone gets sick, so it's probably a good idea to have a living will to tell the doctors and your family what kind of treatment you do or do not want. Everyone has unique beliefs, unique health situation, and unique financial situations. So you and your attorney can determine what's right for you and what you need. Not only that, but you need to think about these things now. Disasters are often unannounced, and the best time to start planning for the unexpected is today. With a lot of my clients who were affected by the flood in 2019, they didn't expect their homes to be destroyed by flooding. They didn't expect to lose work because they couldn't get to their job or their job was shut down for a few days. And then another good example is COVID-19. I did not know that my life would be so different right now. If you had asked me in January, I wouldn't have believed it. So it's good to think about these things right now rather than waiting for something to go wrong. So different powers of attorney, there are two main types. There's general, which can be as limited or broad as you want. It can be, let's say I gave a power of attorney to my sister. I could just give her power to pay my car payments and buy and sell my car, or I could give her control over all of my finances. Like I said, general or limited, whichever you want. The general power of attorney will let your agent take care of certain duties or make certain decisions for you. If you become incapacitated, it becomes invalid. So if, let's say I gave my sister a general power of attorney and suddenly I am in a car wreck and cannot make decisions for myself, that power of attorney ends and she no longer has that power. Another thing is you can revoke it at any time. So let's say that we get in a fight. I can go ahead and revoke that if I feel like I need to. So the other kind of power of attorney is durable. And this is the same thing as a general power of attorney, but it lasts if you're incapacitated. So let's say I gave my sister financial power over me and I get in that car wreck and I'm in a coma. Well, if it's a durable power of attorney, she can still make decisions for me based on what we put in the power of attorney. Another thing is people will make a durable power of attorney that doesn't become valid until they become incapacitated. And this is a good way to avoid guardianships. Here's one good example. If you have a loved one who has dementia and you are worried about making decisions for them, while they still have capacity, while they're still able to make their own decisions, you should talk to them about a durable power of attorney so that if they become when they become incapacitated, you don't have to get a guardianship. Much easier to just do a power of attorney. And it's something that they can agree to. So a medical power of attorney is basically what I was just talking about. It's a durable power of attorney, also known as a healthcare proxy. Like I said, it has to be created during capacity. Your agent can make medical decisions, because it's specifically for medical, on your behalf, and it usually doesn't take effect until you're incapacitated, depending on what you put in the document. Like I said, these documents are all very flexible and you can tailor them to your needs. Okay, so powers of attorney for minors is that really good substitute for a guardianship over a minor that I was talking about. A power of attorney for a minor allows the parent to assign decision-making powers over their children to another person. That's for use when the parent's not available or otherwise unable to make decisions for children. Let's say that you're a single mom and you have found a job in another state and you don't want to pull your kids out of school. So you give a power of attorney for minor to one of your parents, say the grandmother, who can then make decisions in your stead for your kids while you're gone. That the power of attorney for minors, you can limit it by a date. Let's say you know you return on July 1st, and you can end the power of attorney on July 1st. Or you can revoke it at any time. Just say, we're done with this, and take the paper back, rip it up, whatever. Another thing that's good is parental rights are not affected. If you get a guardianship over a child, you pretty much have to show that the parent is not fit to be a parent. In this case, you don't have to show something quite so unpleasant and uncomfortable as that. It doesn't affect parental rights at all. So all these power of attorneys expire at the death of the person who gives the power of attorney. I can have all the power of attorneys in the world for all my different business, but once I pass away, my last will and testament is what is going to control what happens with me and my property. The person named in the will, called the executor, is the person who will handle all the affairs of the deceased. So what does a will do? It expresses your wishes for your property after you pass away. You can include your funeral instructions in here if you want. You name the executor of your will, and this is the person who will be in charge of wrapping up your affairs and distributing all your property to your heirs. In Arkansas, you can make a holographic will. To create one, you just have to handwrite it. That's really good right now during social distancing. If you feel like you want to make a will or need to make a will, you can go ahead and create a holographic will now. You can just write it out, make sure you sign it, and maybe after all this mess is over, you can take that will to an attorney and refine it. But in the meantime, you'll have a holographic will, and those are good in Arkansas. To make sure that everyone can access your will at your death, you can actually file your will with the local probate clerk for a small fee. I think it's $30, or no, I think it's $20. So there's some property that you don't have to worry about putting in the will. That includes life insurance proceeds, trusts, accounts with something called rights of survivorship, which includes like joint checking accounts, and any homes and land any homes and land held in ownership by married persons and something called tenants by the entirety. If you're married and you've bought property, that's probably how that property is owned. And once you pass away, that property won't go through your will. It'll just go to your surviving spouse. So when you choose someone to be your agent for a power of attorney, the person who's going to make the decisions for you, or when you choose the person to be the executor of your will and make sure that all your affairs are wrapped up, there are some things you need to consider. Even though it's pretty obvious the person needs to be someone you trust, you also need to pick someone who is able to handle all of this stuff. Another thing is you need to make sure that they're willing to do it. You can name someone as an executor of your will and they might not want to do it, or they might not be able to do it. They may live in a state really far away and not be able to do long distance estate stuff. So make sure that they are able, trustworthy, and that they're willing. So now we're going to talk about living wills, and there's some confusion with this. A lot of people hear living will and they think it's a will. A living will is actually something called an advance directive, and it controls what happens to you if you become so ill or so injured that you can't make your own decisions. You can't talk to the doctor and tell them what you want. It expresses your personal choices about life-saving treatment. If you're unconscious or near death, basically it will speak to the doctor for you. And you can specify the treatments that you want, the medications you want, or the treatments and medications that you don't want. So maybe things to consider, and I think maybe some of us remember Terry Schiavo and the whole feeding tube thing. This is exactly what a living will is meant to address. You need to consider, if you can't breathe on your own, what do you want to happen? Do you want to be put on a respirator? If you can't feed yourself, do you want to have a feeding tube? What type of pain management procedures do you want? These are all things that you can put in a living will, and like I said, it makes those tough decisions for your family. They'll know what you wanted, and what you want is what should actually happen. Other advanced directives include DNRs, do not resuscitate, DNI, do not intubate, medical power of attorneys, which we already talked about, directives about organ and tissue donation, and any specific illness and specific instructions about a diagnosed illness. Let's say that you are otherwise healthy, but you have cancer. You can say, well, if the cancer is the reason for why I'm not getting better. I don't want to be resuscitated. Things like that. It just lets you be specific. So when you think about end-of-life planning, there are 5 Ds to remember about when you want to review your documents. You need to review your old documents at the death of a close family member. It might change your will, so you might need to go ahead and change that. They may have been your executor, or they may have been one of your heirs. When you get divorced or when you get married, of course, that's going to change things a lot. At the beginning of every decade of your life. So like I'm 38 now. When I turn 40, I probably want to review all of my estate planning documents. If you or your spouse have some kind of health decline, if you're getting older and you've noticed that maybe your memory is not so good, you might want to start thinking about other documents you might need that you don't already have. And of course, important medical diagnoses. If you are diagnosed with something significant or serious, you probably want to rethink some of your power of attorney things. So where do you keep these documents? This is important. So you can keep them in safe deposit boxes, but you need to let someone know where the safe deposit boxes are, how to get in them, and what's in there. If you have a secret safety deposit box and you pass away and no one knew about it, it's just going to sit there. You can keep these documents in online storage, like in the cloud or in your email account. That's something I like to do. Something important that I need to keep track of, I will email it to myself. That way I'll have it in the archives. Another good option is a fireproof or waterproof storage. I had several clients who lost insurance documents and birth certificates and social security information because of the flood. You think about where your stuff is right now. If that gets wet, if you have 4 feet of dirty water in your house, those documents aren't going to be usable anymore. So you might want to look into some kind of fire and waterproof storage. Like I said before, you can file the will with your county probate court for $20. For powers of attorney, give copies to your agent, to the person making the decisions. Give copies to the agent, as well as to any persons who are relevant to that. If I have a medical power of attorney in my brother, then I need to file that power of attorney with my doctor and with the hospital I like to go to, and just make sure that the relevant people get those documents. So that wraps it up. If you have any questions, any specific legal questions, you can call helpline 800-950-5817. You can apply online, arlegalservices.org/apply online. You can email me about any questions about this presentation at hnewberry@arkansaslegalservices.org. Please do not send me personal information and ask for advice, because I can't help you unless you go through the helpline. I think that's all we have today. Does anyone have any questions?
We got a couple in the chat, so okay. Let me see. I'll just read these out. So the first person said, "What was the first type of divorce that you mentioned, and what are some examples of how you prove it?"
Okay, that was general indignities. And you basically have to prove that you and your spouse are not getting along so much and it's been continuous. So an example is, let's say that you are arguing about bills, can't agree on how to raise your children, and it needs to be, it can't be something where you're like, oh, we've been arguing for the past couple of months, like during COVID. I'm sure no one is having the best marital relations, during all this being stuck together. But you need to show that these kind of things have been happening over and over and over. Usually I would say at least 6 months or more. And you would want, and if you can find a witness who sees you fighting constantly and disagreeing about everything, if you have someone who has actually seen those things, sure, bring them to testify. But probably a lot of those things are private, and that's something you'll have to testify to yourself. You'll just have to make sure that you tell the judge how continuous it's been, give specific examples. Don't just say we fight all the time. Give specific examples, and yeah, maybe have dates and times even.
Cool. And the other thing that they asked this particular person was, if you go the 18-month route, it said you're living separately. How do you go about creating a custody agreement?
Well, the custody agreement is something that's going to be in the divorce. So the 18-month separation and the general indignities, those are just grounds for divorce. So when you make a divorce complaint, you're going to have the grounds in there, but you're also going to have any kind of property division and any kind of child custody or visitation issues. They're all going to be in that complaint. So
Cool.
I guess
sorry.
I mean, depending on why you've been separated for 18 months, say your wife just ran off and you haven't seen her in 18 months and you don't know where she is, you're probably just going to want to ask for sole custody and be like, we'll look at visitation if she shows up sometime. It's really depending,
Sure. Okay, so the next person said they had several questions about let's see, they had several questions about revocable trusts. The person says, how would they change the executor of their estate, and can they do that holographically? And they said also, if they have a revocable trust as a person who is receiving your quote unquote stuff, you need to have a blind trust already created.
Okay, so as for changing the executor of your estate, I guess by handwritten, that's probably what they mean by holographically. No, you need to see the attorney that prepared it or an attorney of your choice for trust. I don't do a lot of work with trust. The nature of my work means that most people that we serve aren't going to have the kind of assets that need a trust. So I really can't answer any specific questions, but I can definitely tell you that if you need to change your executor, you need to speak to an attorney who will do that for you.
That makes sense.
Yeah.
It seems complicated.
Yeah, well, it's like you can't change it holographically. I mean, there may be a way you can do it yourself, handwritten, but it's going to be really complicated, and I don't advise you do it without an attorney's help.
What other questions do folks have? Okay, so the person who was asking the divorce questions earlier also asked whether y'all's organization helps with those.
We do help with divorces. However, because there is such a huge demand for people wanting a divorce who fall under our guidelines, we actually have narrow case acceptance guidelines. And usually, even if you fall under our guidelines, if there's no abuse in the marriage, if there's no physical abuse in the marriage, we probably won't be able to take it. However, if there has been physical abuse, I highly recommend that you call us and have helpline person do your intake and everything, and they'll give you a little advice, and they'll have an attorney look at your case. So if there has been physical abuse in a divorce, yes, definitely call us. As for anything else like just custody, we have same thing. We have very specific guidelines, and I really just recommend you to call the helpline and see if you qualify, because I don't want to misspeak and encourage someone not to call when they may have qualified. All right, thank you, everyone.
Thank you. Night.